¿Qué pues, pinche gringo mamón? Si tengo mi green card. ¿Qué pues, pinche gringo mamón? Si tengo mi green card.
Thanks for your collaboration. And remember, don't
¿Qué
come
pues,
back
pinche
again.
gringo mamón? Si tengo mi green
Thanks
card.
for your collaboration. And
Y el
remember,
gringo nos
don't
quiere
come
curar
back
el
again.
muro, mamón. Dile que no, pinche gringo racista. Pues no te pagaremos nada.
Wait a minute, please.
Somos gente honrada y...
Good evening, everybody. Welcome to Viewers Discretion. I'm your host, Joe Neerman, aka Good Lawgic. I thought that particular video was appropriate for tonight's topic, which is why I brought it out for you. As this case that I plan on covering tonight is obviously related to Laken Riley, who became the flashpoint for what many Americans have been feeling for a while was a concern that actually, unfortunately, manifested in the tragic murder of an innocent life. It was cut short for no benefit, no reason. So, I do plan on live streaming the trial. I put up a little goal, but it's probably the goal is probably of if I get 10 yellow super chats, I'll live stream the trial tomorrow. But the goal is probably I'm probably going to end up doing it irrespective of that. I do want to give you all a heads up that tomorrow afternoon I'm going to have to join Lady Lawgic on a family thing. So I'm going to be streaming in the morning tomorrow. The trial, picking up where it's up to, and if it continues into the afternoon, at a certain point, I'm going to have to stop. So, did want to give you a heads up on that. But what I figured is it's appropriate that before I start live streaming trial, that we're all on the same page, caught up as to exactly what this case is about. Everyone. I think most people have heard the name Laken Riley and associate it with a young girl who was murdered by an illegal alien. It was a topic that Biden even brought up at his State of the Union address in March of this year. She was murdered in February. And embarrassingly, I think he mispronounced her name as Lincoln, which just says everything you need to know. Well, anyhow, so in order to catch up on this trial, I think it's important for us to get a little bit more about the background of the story, understand a little bit more about what's been happening so far, and I plan on reviewing oral arguments with you, and this way we get a feel for what the charges are about and what's been going on. So this way we come into tomorrow, we're all, yeah, he said Laken Riley, as I recall, Steve. It's pretty sad. I remember correctly, right? I'm like 99% sure he said Laken Riley, which is pathetic. Anyhow, so I want to just share with you where we're at, what's been going on with this trial, a little bit of background about Laken, and hopefully we could all be caught up as we start this and get a better feel for what is going on. So, with that, here, this is not what I wanted. Apologize for that. Head start. It was a New York Times thing. That's where it was. All right, just get a brief overview. I knew I had it here somewhere. Just a brief overview of the killing at the University of Georgia. It's broken down. This is the New York Times just backdrop of the whole thing. This is not about the actual trial itself. What I plan on doing is when we get the backdrop, we'll go through the openings, probably not all of the openings because I want to have a short show. The trial starts tomorrow morning at 8:30 a.m. Eastern. It's obviously very early, which means I can't run very late tonight. But I want to. The whole goal here is to be caught up on everything. So let's start with what we got. So it's broken down by the New York Times. President Biden said in a State of the Union address that a nursing student was killed by an illegal. The authorities called the homicide in February a crime of opportunity. That's crap. When President Biden went off script during a State of the Union address, responded to a heckling lawmaker by saying an innocent young woman was killed by illegal. That's right. The body of Ms. Riley, a 22-year-old nursing student at Augusta University, was found in a wooded area at the campus of the University of Georgia in Athens on February 22nd of this year. After the authorities revealed the next day that they had charged an undocumented immigrant from Venezuela, Jose Antonio Ibarra, with the murder of Ms. Riley, the crime became a political flashpoint in Clark County, a community about 70 miles east of Atlanta, and nationally. Authorities said the suspect and the victim did not know each other. Many other questions remain unanswered, so let's get a little look at her. Riley was once a student at the University of Georgia. Until the spring of 2023, she then enrolled at Augusta University's nursing program, which was a campus in Athens. She was on Augusta's fall 2023 Dean's List. Bianca Tiller, Ms. Riley's freshman year roommate, said that Ms. Riley lit up every room she walked into and brought a smile on everyone's face. Ms. Riley was an experienced runner who participated in the Georgia High School Association State Cross Country Final several times. Her former coach, Keith Hooper, said in a statement that Ms. Riley was an unselfish individual. Mr. Ibarra lived in Athens, was from Venezuela, lived about 1 mile from the wooded trail where the body of Ms. Riley was found, according to Jeffrey Clark, the chief of the University Police. Migrated from Venezuela, he was arrested by the Border Patrol for entering the United States illegally in September of 2022. Which was like roughly 16 months before the murder, and was released quickly with temporary permission to stay in the country, according to federal officials. Such releases, called paroles, were once common when officials were overwhelmed with a large number of border crossers, says the New York Times. So that's their own editorializing right there. The Biden administration ended the practice about 6 months after Mr. Ibarra's release, so that's very nice. According to U.S. Immigration and Customs, New York Police Department arrested Ibarra in August 2023 and then released him. Law enforcement official in New York City said Ibarra had been driving a scooter without a license and with a child who was not wearing a helmet. Ibarra was arrested in Georgia in October in connection with a shoplifting case, according to Athens Clark County Police. Officials there said they ran Mr. Ibarra's name through state and national database at the time, but did not find a warrant for him. Once again, he was released. After his arrest in the murder case, Ibarra was denied bond and remains in jail. So that's his background right there. That's what you need to know about Jose Ibarra. What is he charged with? I'm going to start there. What's he charged with? This is Judge Haggard, and he's about to read out the charges.
Charged with 10 counts. 1 count of malice murder, 3 counts felony murder, 1 count kidnapping with bodily injury, 1 count aggravated assault with intent to rape, 1 count aggravated battery, 1 count obstruction or hindering a person making an emergency telephone call, 1 count tampering with evidence.
It is, right?
1 count peeping Tom.
1 count peeping Tom. 1 count peeping Tom. Now, what we're going to see throughout the course of this trial, first of all, is peeping Tom is, we're going to hear a story about how he allegedly, a woman accuses him of knocking on a door multiple times. And then she was in a shower. Then he went around to look through the window into her house. And that is the charge of peeping Tom. So they actually have pretty good evidence on the peeping Tom because she's a witness, sort of. She couldn't ID his face, but ID'd his clothing, as we're going to see. But that's the peeping Tom charge. you're going to be, it's what's interesting about this case is they don't really deny that she was murdered. The defense is going to, and this is first and foremost what's interesting about this case is it's a bench trial. Very, very unusual to have a bench trial when you're talking about a murder case. As you know, the right to jury of trial by your peers on the Sixth Amendment, which applies for reasons that are beyond my belief, but certainly the opinion of the Supreme Court, that Bill of Rights applied to illegal aliens completely. And so he has a right to a jury trial. His counsel waived that right to a jury trial in favor of a bench trial. Very unusual. You almost never see that. Depending on the jurisdiction, it will vary as to whether it is sole discretion of the defendant. I was seeing lawyer say that in Florida, you would need permission from the prosecutor, which prosecutor is always going to give it to you if you want to have a bench trial, that they prefer a bench trial. I guess less likely things go wonky in a bench trial. In other jurisdictions, like I saw someone saying that in Illinois, for example, the prosecutor has no say in it. It's completely up to the defendant. That is more logical to me. That's more logical to me because the right to a jury trial is that's a right that's guaranteed to the individual, not to the state. So if the individual who's accused would prefer a bench trial, you would think that should be their sole discretion. Let's say we're talking about a hypothetical scenario here where Barr would ask for a bench trial and the prosecution would be like, no, we want a jury. Would they have that authority? I haven't checked up the law in Georgia to know what how that particular state weighs in on this particular issue. To me, it's most logical to say that should be solely the discretion of the defendant, and the prosecution should have no say in the matter. But you would ask, why would he take a bench trial? Well, the answer is, I don't know, maybe because President Biden referenced him as the one who murdered Laken Riley. He figures, good chance people on this jury here, really, not most Americans who are going to bring into a jury pool are going to want to hang me, whether or not there's sufficient evidence. Obviously, when you're talking about a criminal trial, you have to have proof beyond a reasonable doubt. Where that yardstick is between I think he did it to I'm pretty sure he did it to positive beyond a reasonable doubt that he did it on each element of the crime, perhaps juries are a little bit too quick to jump from I think he did it to beyond a reasonable doubt, particularly if they've been inflamed. One of the reasons that we always talk about evidence being more probative than being prejudicial is because if it's prejudicial, jury gets all inflamed and gets out the pitchforks and the torches and and they start marching looking for blood, and they're going to have their eyes squarely on you, even if they don't have proof beyond a reasonable doubt. That's certainly a valid concern in a situation like this. I don't have the Redwell, which is a reference that lawyers use to like the ones who are behind the case to know the strategy. Ultimately, it would be the defendant himself, his own decision. It's not up to his attorney if he wants to waive that. But attorneys are going to be pretty convincing. And you can understand why an attorney would suggest in this particular case, maybe we can get a judge who's going to be more about reaching that yardstick of beyond a reasonable doubt, and that they feel like they have a better chance of getting that from a judge and really focusing on like, okay, maybe I get that you probably think you're probably pretty sure he did it, but are you really beyond a reasonable doubt? And that's probably where the attorney's defense counsel is starting with. When covering this, it's important to try and look at, even though that this guy, in my heart of hearts, I'm with you on this. Okay, so I'm going to say this. In my heart of hearts, I'm like, this guy did it, and I want to see him. Frankly, I'm disappointed there's no death penalty. Okay, this guy's slime. You don't have to convince. It's not like, but at the same time, it's important that we go through the process properly and assess, have they met their burden? Now, with respect to the issues of sexual assault, which are referenced in the charges there, that's actually where the state has its weakest case. We're going to see that they have a lot more evidence with respect to the charges that relate to the murder than they do with respect to the SA. They have a lot less evidence when it comes to the SA. But with respect to the actual murder charges, their case is pretty strong. And the opening statement that's made by the prosecution, from what I've seen, seems pretty strong, pretty thorough. I haven't gone through all of it, but what I'm going to do is we're going to be watching it together. And if there's nothing else I need to address here other than this one chat, we're going to start in a moment. Hope you still have those Lions in your fantasy team. My son, my only son Moshe, whom I love, took me and his oldest son to see the Lions crush Jacksonville. I do. If you are wondering, I will tell you right now that I don't think I've ever had as much of a fantasy crush on any player in my life the way I have on Amon-Ra St. Brown. I do. That guy is the most consistent producer week after week after week after week after week. It's like even a Jamar Chase has like off weeks. I think he actually had one off week this week, couple weeks back, where he had like under 10 points. But then I have him on one league. I've got Jamar Gibbs in another league. They're a very solid team. Should be proud. Now they just got to do something in the playoffs. But yeah. All right. Let's get to it. Without further ado. That's very loud.
On February 22nd, Jose Ibarra put on a black hat, a hoodie-style jacket, and some black kitchen-style disposable gloves. And he went hunting for females on the University of Georgia's campus. And in his hunt...
That's a very powerful opening line. He's going hunting. But this is like a predator. So it's a very powerful first line there. Not going to catch you.
He encountered 22-year-old Laken Riley on her morning jog. And when Laken Riley refused to be his rape victim, he bashed her skull in with a rock repeatedly. That is what this case is all about. The evidence will show that Laken fought.
It's very tough. I'm with you. I couldn't do it. I don't think I could do it. I'm with you on this.
She fought for her life. She fought for her dignity. And in that fight, she caused this defendant to leave forensic evidence behind. She also marked her killer for the entire world to see. The forensic evidence that he left behind in this fight is his DNA, and only his DNA and Laken's, underneath Laken's right fingernails. He also left behind in a struggle with her over her phone, because the court will hear that she called 911. He left behind his left thumbprint on her iPhone, which was found not far from her body at the crime scene. And it is that forensic evidence alone that would give you enough evidence to find him guilty as charged on the counts in this indictment.
Well, this is like, you can tell out of the gate, this prosecutor is crushing it. Sheila Ross, she's crushing it. I mean, she opened up and saying, this guy went on a hunt, and we have ridiculously powerful evidence, short of something where we can show you or have someone come in here and testify that they saw it happening. But an incident like this, where, you know, there's an initial mystery on the whodunit, and now we have to find the killer. You could not ask for more powerful evidence than DNA, fingerprints, scratches under his DNA under her fingernails, scratches on his face. I mean, you really couldn't ask for more with respect to these murder charges.
The evidence in this case will come in basically three forms. There'll be forensic evidence, there will be digital evidence, and there will be video evidence. And
now, the digital evidence is a reference to different tracking things with respect to her phone, showing when she's running, when she stops running, where she is, and all that other stuff to tie in their correlation that they're in the same place together. They had the forensic evidence that she just referenced. The video evidence relates to how they tracked him down, as far as seeing him on camera throwing away some of his clothing and trying to basically do the whole peeping Tom thing, and other evidence with respect to his timing as to where he was at certain times.
all three forms of those evidence will point to one person, Jose Ibarra, as the killer of Laken Riley. And this is not working. We'll start with the timeline, and the timeline is established by a lot of the digital evidence that you're going to hear about. And for Laken, that timeline begins basically at 9:03 in the morning. At 9:03 on Thursday, February 22nd, Laken Riley did something that she does all the time, and she went out for a morning jog. She lives not far from the crime scene, and Your Honor is going to see several maps in this case, and you will see that where Laken Riley lived, where the defendant lived, where our other victim who you're going to hear from in this trial, Tasia Swee, lived, Building S at the University of Housing, at University of Georgia Student Housing, and where items of evidence were dumped in this case and where Laken was murdered. It's all clustered together. And it's all clustered together within about a half-mile radius of one another. And you'll see several maps throughout this case. But she left her house at 9:03 in the morning. We know that for several reasons. She was captured on her Ring doorbell. And you'll see that video through our first witness. And she also was captured on a trail cam that becomes very important in this case. And at about 9:05 a.m., she's captured running from her house down Rogers Road, eventually towards the crime scene where she encounters this defendant. She is running, as you will see, with a few things that are important. 2 AirPods, and they are noise-canceling AirPods. And her phone,
it's our strength.
iPhone, is in her left
It's our
hand.
strength.
She's wearing typical running clothes, and you're going to hear a little bit about how she runs, what she runs with, because these things are important to judge what eventually happened between her and this defendant on the trail. She wears typically very tight running clothes because that's what's comfortable when you run, so it doesn't get it doesn't come off or get loose when you're running. And so this particular day, she's wearing running tights, white Hoka shoes, and 3 layers of clothing on her top. She's wearing a running bra, a shirt, and a tight black Lululemon jacket when she leaves her house. At 9:11 a.m. exactly, Laken is a few minutes into her run, and we have some digital data which we'll talk to you about, which is a Garmin watch that Laken had gotten for Christmas that she's wearing on her run. And this watch captured a lot of important data that you're going to hear about. But she is on her run, and her phone, she activates the emergency function of her iPhone, and you're going to hear about that through testimony of the witnesses who examined her phone. She activates the emergency function of her iPhone, and she attempts to call 911, and she, in fact, does call 911. Her call is connected to ACC PD. At 9:12, you'll hear that the call was hung up, and I'm going to play the call for you. At 9:12, the call was hung up by the caller, not the 911 center. The 911 center did not hang up on Laken Riley. The phone hung up. And at 9:12, they tried to call her back, and there was no answer. This is an enhanced version of the 911 call, and there will be several stipulations between the parties in this case. We will execute a waiver of them as they come in. One of the stipulations was that this 911 call was sent to the FBI in Quantico, where they attempted to enhance the call. And this is a 1 minute and 8 second call, and this is the enhanced version of that call. And I'd like the court, when listening to the call, right about 55 seconds into the call, you're going to hear a voice.
Now, one of the quirks of a bench trial is that the judge has the unique role, which people question how someone can do this, how one individual has the capacity to do this. I'd be curious to your thoughts below. Do you think a judge is able to do this? That when it comes to purposes of making a legal ruling, his job as the trier of fact, because he's taking the place of the jury. So whenever you have a trial, you have questions of law and questions of fact. And there's certain things that are not supposed to come in to a trial in front of the jury because it might wrongfully give them to draw some conclusions that are not really based on good evidence. They're based on hearsay. They're based on evidence that has poor foundation, or anything that's any of a myriad of different flaws that you can have with evidence, which would make it ineligible to be presented to a jury. So over here, you have a unique scenario where, I mean, it's certainly unique in a criminal trial setting. It happens all the time in civil court, but a trial in a criminal trial setting, it's a unique scenario where you have someone who is hearing arguments back and forth as to why evidence should come in, and then deciding yes, it should, or sometimes no, it shouldn't. And then as the trier of fact, he has to pretend that he didn't hear those arguments. When he's listening as the person who's deciding what facts happened, he has to pretend he has no knowledge about this other evidence that he excluded, if in fact it ends up being excluded. You can have a moral question as to how any judge can pretend he doesn't know of the existence, he or she, if it's talking about a female judge, is unaware of the existence of certain evidence that's being withheld, that he decides not to admit to the trial. Especially sometimes they even have to review it and then keep it out of their mind and pretend it's as if it doesn't exist because it's not admissible for trial, which seems pretty close, if not very difficult, if not impossible, incredibly difficult to really do that. But that is the job of the judge who's sitting over a bench trial.
Clark County 911. Hello, this is Clark County 911.
This that we're listening to here is when she used an emergency function to call 911, but obviously wasn't able to talk.
Hello, Clark County 911. Can anyone hear me? Clark County 911.
Most criminal trials, they are now forced to wear an orange jumpsuit because you don't want to prejudice the jury. And in this case, the judge is the jury. Just gives you a visual, which makes you feel as if the guy's guilty.
Yo,
Smile and
Tango.
comment. This is an interesting quirk of this judge. I don't know if it's because he's sitting on a bench trial and there's no jury there. It is a little weird that he's not wearing a robe normally. I've never seen. I've gone out, even when it's not a trial, just a hearing or something like that. I've never seen a judge when they're sitting on the bench not wear a robe. It's very unusual.
A long break, and what happens next? It was Laken's mom, who Laken usually talks to on her run, who started calling Laken at around 9:06 that morning. And you'll just see the call logs from that and the evidence of that through Laken's phone. And when she could not reach Laken, she began calling Laken's 3 roommates.
What a strong opening statement this prosecutor is giving.
What? I didn't know. Stop it.
talking about how Jose Ibarra allegedly went, they say,
Oh, come on.
what a fight this is going to hear in the
What?
nursing, that this go
That wasn't what I
badly
wanted.
with a rock.
I don't need to hear from you. Sorry about that. I figured if I go to the 113, if I go to the one that's an hour and 13 minutes, I'm going to cut that stuff out. I think they paused it. And then, sorry about that.
Roommates, and you'll meet all three of them: Lily Steiner, Sophia Magana, and Connolly Huff. All three of them are University of Georgia students at the time. They were all seniors. And Laken herself was at UGA, but had recently transferred to the University.
I did not say he could not be impartial. I didn't say that, and I don't believe that to be the case. I think he can be impartial. I'm simply saying that when a judge has a dual role of deciding whether or not evidence is admissible, any judge is in a position where it's like, you know, we have this evidence we want to present to you, and the judge has to decide am I admitting it or not. And then if he decides to reject it, and then sits in his seat as the trier of fact, pretend he hasn't seen or heard whatever he's just excluded, many people would argue is impossible. It's like pretending, that you never, that you know nothing about. So pretending you never heard of the Constitution. Like, how is someone supposed to just pretend that they don't know the existence of something?
Augusta Athens campus because she wanted to be a nurse, but the four of them still live together, and the roommates are all, I would say, technologically savvy and security savvy, and they all four had iPhones, and there's a function with an iPhone called Find My iPhone, which you can share your location with other people, and the four ladies in that house, roommates, shared their digital location with one another 24/7. And so when Allison Phillips, Laken's mom, began calling and looking for Laken, she notified all the roommates. And then the roommates started checking their indoor camera, checking for Laken, texting Laken, calling Laken, and no response. I will say that this particular day, February 22nd, 2024, happened to be the day where there was a widespread phone outage by AT&T. And so some of the girls did have AT&T as their service provider. Laken did not. She's Verizon. And so the girls were having phone problems due to that widespread outage. And so you'll hear about how that kind of interfered with their ability to really find where she was. But eventually, they could not find her. They could not find her for hours. And even though Laken would go out on long runs, she always had her phone with her, so they became concerned. So at around 11:30 on the day of her murder, two roommates, Sophia and Lily, went and walked the trails back behind the intramural fields at the University of Georgia where Laken used to run, but they also had her digital profile. And her digital profile put her in the middle of the Oconee Forest, and they had noticed that she had not moved. She had not moved for hours. And so they walked to where they could last see her digital profile, and the two roommates found one of Laken's AirPods. They photographed it, they collected it, they went back to their house where they could have Wi-Fi to connect because they had no phone service in the forest and the outage was on. And at 12:05 p.m., they called the University of Georgia police and reported that Laken Riley was missing. So it isn't until the police respond immediately. And they take that digital profile, and you'll meet Sergeant Maxwell. He is the...
Which is interesting to me that they responded immediately, because you might think that they would say, well, she's grown. She's grown. She's an adult. And normally someone's been missing, you would think, for like 24 hours. It's a good thing. That I'm not saying this critically. I'm saying it's fortuitous. Officer
that found Laken's body. And it takes him, even with her digital profile, this is a very forested area. And she obviously wasn't on the running trail. She was off the running trail. And it took him about 25 minutes, even with her digital profile, for him to locate her. And he did locate her, and you're going to see the body cam footage of him locating her. And what he found when he found her is that she was hidden kind of almost under a tree and covered up with a bunch of leaves. The first thing he noticed was that her breasts were completely exposed. All 3 layers of her top clothing were pulled up above and around her neck. He also noticed that her running tights, which she typically wears above her navel, were pulled down and her underwear was protruding from her tights. He also noticed severe injuries to the left side of her head.
Now, these are all designed to help prove the SA charges. Obviously, it's not a normal way for a woman to be running. And, you can speculate as far as that being the same level of proof. And I'm not saying that he's innocent. Please don't mistake that at all. If I'm not crystal clear, people will draw the wrong conclusion. I'm talking about, do I think he did it? Yeah. Do I think that you can go all the way from an assumption of innocence to reasonable proof beyond a reasonable doubt that this must have happened? This must have happened. And there's no other possible explanation that's logical or reasonable. It's certainly not. You don't have the same mountain of evidence that we get to on the murder that we have when it comes to the SA. That's all I'm saying on that. I think there's a lot of evidence. Do I think he engaged in SA? Oh, hell yeah. Did it reach reasonable doubt? We're going to see that the defense is going to try and hit on that particular charge. Really harder than on the murder, which is a little bit of a strange thing. But hit on that particular charge saying you don't know that he engaged in some sort of conduct like that beforehand. If Schultz on Hogan's Heroes could I see nothing, a judge should be able to do the same. Yeah. Fair enough. I hadn't considered that. That's a good point.
He began immediately trying to save her life, but he could tell that she was dead. She was cold. But he began CPR, and you will see the efforts of him and several other University of Georgia police officers where they try to save her. They have to move her out of this area so that they can get her flat on the ground. They give her chest compressions. They give her CPR. They put those pads on her chest to try to start her heart. Eventually, the fire department and EMS comes and they do the same. And they work her for several minutes, but she is dead. She is dead. And there was nothing they could do to stop it or help her. You'll see the crime scene measurements. The crime scene in this case was worked by the GBI in conjunction with UGAPD. You will hear in this case from GBI, UGAPD, FBI, and ACCPD. The 4 of them really in conjunction worked this case. And the crime scene, importantly, when they get there, there's really very few items there. But item number 1 where you see on the trail is the other AirPod that Laken was wearing at the time that she was running. And then they saw a disturbed area of leaves to a point where they found 2 rocks and a tree, both of whom or all 3 of which have Laken's blood on them. And then Laken's body was a few feet away from that where you see the green there. And then her phone was not found near her body. It was found where you see item number 8, which is the other tree that you see there. But her person was taken 64 feet off that trail. So from where AirPod is, item number 1, to where you see items 2, 3, and 4 is 65 feet. So in legal terms, he aspirated her 64 feet off of that trail so that he could attempt to victimize her. This is the crime scene, and you'll see how wooded it is and why it took Sergeant Maxwell so long to find her, even though he did have her digital profile. And in here, this photo is actually the phone. And so it took them a really long time to find the phone. They were calling the phone. They were pinging the phone. Her phone was on silent, so they couldn't hear it. I mean, it wasn't until it got dark that they could find her phone, but they kept looking for her phone because they knew the phone was there. And they found it. And when they found it, this is what Daniela Stewart of the GBI saw on her iPhone, exactly where your phone would be if you go to hang up a call on an iPhone. So at the bottom of the iPhone.
This is a horrific story this prosecutor is telling, doing a tremendous job with the advocacy work for this judge here. Let's hear.
Yeah, I think she's doing a great job.
What?
Oh my goodness, really?
Go back in.
She found this latent print in blood. They processed the phone immediately, and that latent print was sent to ACCPD. And we'll talk about that a little later.
It does seem completely
and here's some of the
unmoved.
Garmin data. And there are some things that we will never know about exactly what happened between Jose Ibarra and Laken Riley on that trail, but we know enough. And what we know is that at 9:10 a.m. from her Garmin that she was wearing, as she is trucking along and she is clipping 7-minute miles, she's running, doing her thing, listening to music, something happens. He does something to her to make her stop dead in her tracks. She initiates the SOS function on her phone and calls 911, and she immediately stops. And after that, you'll see some of this Garmin data, her movement, because it went to the FBI CAS team. They're the ones that analyzed it. You'll hear about it. She's on this trail with this defendant for about 4 minutes. And then you see 4 minutes later, her Garmin move 65 feet into the woods. And there's some additional movement of her along that time. And her heart rate is still going until 9:28 a.m. Her encounter with him was long.
And terrifying.
Her fight with him was fierce.
It was long and terrifying. That's why her heart rate is just is no different than if she was actually running.
And that is what the Garmin data shows. And once her heart stops at 9:28 a.m., there's no more movement from her Garmin. So
it's amazing how much you can glean of a story just from the digital evidence alone. Forgetting the forensic evidence, just the digital evidence just tells you so much about tells us more than pretty much probably anything else we're going to find as to like what actually happened from the moment she met him until she died.
what happens next? Well, UGA PD leave, and they really got nothing other than a peeping Tom incident that had occurred on campus at 7:57 a.m. I'm going to talk to you about that one last. So what they do is it is a combination of good police work and luck, pure luck. But they start dumpster diving. ACCPD is dumpster diving, UGA PD is dumpster diving, GBI is dumpster diving, FBI is dumpster diving. Everybody is just looking into every dumpster in the Athens area for anything because they had nothing. And at a dumpster.
That's an amazing admission that they're like at this point, there's no Jose Ibarra known about. All we know is we have a body, she was murdered, and we have nothing as to who did it and who's at fault. Because ultimately, the role of the prosecution is to tie it together as to like, okay, clearly she's been murdered. Likely, it seems like, more than likely that there was some level of SA there. What level? I don't know. You would think that if there was actual penetration, that there would be DNA evidence of that, possibly. Like you can ask a question, like the defense, and I have to play devil's advocate here because otherwise there's no point to watching a trial, right? So I sort of have to play that role, even though I know that this guy is scum. Okay, I understand he's scum, but the idea is for us to better understand how the law operates and what standards we have to reach for these protocols. So, if you're a defense counsel here with respect to that SA charge, you would be pointing to the lack of forensic evidence, assuming that there is a lack of forensic evidence with respect to the SA, to say no bleeding, no tearing, and things of that nature, which you would try to use to establish that, hey, there wasn't actually SA here, that there was something else that happened, that that even if you tie him to the incident, which they still have yet to do, and she's going to lay out and tie him to the incident, and they have a ton of evidence to tie him to the incident. Don't worry about that. They have a ton of evidence to tie him to the incident. We already saw that there's his thumbprint there, and we heard about the DNA evidence and all that other stuff. But with respect to the actual, just the SA, as far as what evidence we have. So, that's something that you would try to point to. Is that enough to get you off? I don't know. We have to see what evidence comes out. We have to see how it's, how it's presented and how people, what testimony we get from different experts who, were there at the scene and what they saw and what they tested and things of that nature. But that's certainly an area the defense goes to. We should expect them to go to that through the course of the trial.
At an apartment complex where he lived, a police officer named Zach Davis of ACCPD finds this hoodie jacket. And when he looks in and sees it, it's in a recycling bin and it's standing out because it's right on top. And he noticed it had long, dark hair on it, wrapped around one of the buttons, and he could see blood. And he thought that was suspicious. So he calls UGA PD. They respond at 9 o'clock on the day of Laken's murder.
That is amazing good fortune. You have a hair and blood on clothing that's been discarded. That's amazing good fortune.
They collect the jacket found in the dumpster and they send it immediately to the GBI Crime Lab indicator for testing. But while they're there, they look around and see that one of the residents in this apartment, and B32, had what's called a Eufy camera, which is like a Ring camera, but works a little different, had a camera aimed at that dumpster. And so they asked the resident that night, hey, can we come in? Can we see your camera? He agreed to let them see it. And this is what they saw. At 9:44 in the morning, about 15 minutes after Laken Riley's heart stopped, this is what they see.
Man, caught on camera dumping the jacket.
With this pause here, I want to bring in our guest analysts who are watching along, Jennifer Coffinduffer and Joe Tamburino. Jen, I want to...
15 minutes after she's dead, they catch him on camera. Now, defense is going to say, you don't know it's him, whatever. They're going to tie in that it's him. Don't worry. But 15 minutes after she's dead, they have him, dumping off his clothing, with her hair and blood on it. Wow.
Welcome to our second. Nothing short of horrific.
So they saw an individual who they did not know who it was at the time, dump the jacket in the dumpster and go to those bushes there and dump something there. So they go to the bushes, and this video has been enhanced, and I'm sure you're going to hear a lot of testimony about this video, enhanced the best they could by GBI Cyber. And I know the court sat through some motions to suppress where this black Adidas hat, there was a lot of discussion about, and you're going to hear more about all of those things.
And you can see, I'll make it a little bigger just to make sure that you all can see it. That up here, this is clearly an Adidas hat, which is going to come relevant on this whole thing here. So take note of the clothing.
But this is an image that they locked in on and began to circulate around the neighborhood, or as the cops call, a bolo. Be on the lookout for this individual. They didn't know who he was, and they circulated that. But they did go also that night, still the night of February 22nd, to the bushes, and they found 3 black disposable kitchen gloves. And those gloves were...
And his build is important because apparently his brother Diego is found later wearing the hat. and you need to know you have the right guy, that it's him and not his brother. And while DNA is going to match him and not his brother, if you're the defense, you're going to try and say it's not him, it's his brother. But his build is, from what I understand, I haven't seen the brother, but I think his brother has a somewhat noticeably different build.
Also sent immediately to the crime lab. And one of the interesting things about the black disposable gloves, when they got to the crime lab and they were analyzed, this is a picture taken at the crime lab, is that on the thumb of the gloves, there was a hole. There's also...
So you can see what probably happened, what likely happened, is she scratched a hole in his gloves because he was wearing gloves. We know he was wearing gloves, and he ditches the gloves in the bushes. And you can ask yourself, how's his thumb on her phone if he's wearing gloves? And the answer is, well, there's a hole. Thank God. I mean, this is like miraculous. It's miraculous that they got the levels of evidence they did, considering, you know, he took steps to try and mask his identity, and I guess God intervened and helped us find the evidence.
Other holes in the gloves when they found them, but on the thumb area of one of the gloves that the crime lab examined, they found a hole, and they also found blood, and that blood was later to be determined to be Laken Riley's blood on those gloves.
And on this, I just want to point out, okay, I'm catching up on evidence and all the background of this trial. I was obviously very familiar with the trial. I knew about her murder, but as far as the details here, it's very possible that many of you are going to know things about this, about the factual underpinnings here that I'm first learning. So feel free to share something like this. You know, this brother's solid alibi. Appreciate it.
So I've already told you about the geographic locations. They're all clustered. You can see in this map, the crime scene is up top in the middle, called body crime scene. The dumpster where the items were found is marked. Building S is right by the bus stop, and then Laken Riley lived further up, Millage Avenue, towards the top of this photo. But the distance between the Building S, which will become important, and Laken Riley's body is about 300 yards. The distance between the dumpster and Laken Riley's body is about 500 yards. And the distance between the dumpster and the bus stop and where the defendant lived, because he lived in that apartment complex, is about 150 yards. Everything is close together. So what happened next in the investigation is that the very next morning on Friday, February 23rd at 8:32 a.m., as ACCPD, again, is just looking out for anything. They had the bolo at that point. They encounter a person named Diego Ibarra. And Diego Ibarra is wearing a black Adidas hat that is some interest to them, which is they believe to be the identical hat that they had seen in the video the night before. And I will tell you this, on that hat that Diego Ibarra was wearing the next day.
He also doesn't have the same facial hair that Jose has. Is
Laken Riley's blood. So their theory that was in fact the same hat was absolutely correct. So they encounter Diego Ibarra. He gives them a fake green card. They know it's fake because it has 2 different dates of birth on it. And so they ask him to go back to his residence, and they begin talking to him. UGAPD arrives, and they begin to take over the scene. From the information that they had gotten from Diego Ibarra, they knew that hat was a hat seen in the video because of the proximity of the crime. And at some point, Diego began telling them he's got brothers in the house sleeping, and there were many communication difficulties at first because the first responding officers did not speak Spanish. No one in this apartment, D126, could speak English. So at some point, UGA brought 2 of their Spanish-speaking officers on scene, and the communication became a little easier. Officer Bridges, Officer Sand, both of whom are native speakers of Spanish, arrived and began taking over the communications. When they get there, they are attempting to secure the residence for a warrant. And before they could do a security sweep to secure the residence for a warrant, Jose Ibarra, who's in the middle in this slide, comes out with a garbage bag in his hand. He eventually gives officers consent to enter the residence. And when Sergeant Epps enters the residence. He sees Jose Ibarra asleep in the bed. And that is how he's been identified in this case. You will see there are 5 residents that lived in apartment D126. Jose Antonio Ibarra, this defendant, also goes by the name of Victor, which will be important because a lot of the communications within his phone and some of the witnesses just call him Victor. So Jose Ibarra is Victor. It is in fact the same person. Diego Ibarra is Jose's older brother, goes by the name of El Gocho, is a nickname that many people, including this defendant, call him El Gocho. Argenis goes by Manny, and Rosbelli Flores Bello goes by La Gorda, and then Juan Carlos Diaz Hernandez, they call Carlito. And I suspect the state will tell you right now, you're going to hear from Rosbelli and that residence. You will also hear that all the residents, Diego, Argenis, and Rosbelli, at least those 3, are currently in federal custody on some immigration issues. But we are going to produce Rosbelli to testify to the court about the things that she saw and observed that day. And it is Rosbelli who identifies Jose Ibarra from the dumpster video. The officers, when they saw Jose Ibarra that day, saw that he had many injuries to him. Scratches on his arm, scratches on his wrist, scratches on the back of his neck, scratches on his hand. And they photographed those injuries to him. And then they began to do an additional.
I'm not going to kid you. I don't see scratches there. I'm not saying they're not there. I'm sure they are. But maybe over here. I don't scratches to his hands. I'm not sure.
To him. And then they began to do an additional canvas of this entire apartment complex. There are multiple buildings in this apartment complex, A, B, C, D, and E. Multiple teams of agents began going around looking for cameras, talking to residents. What do they know? What do they not know? And one of the things that they found is that the Ibarras lived at D126. Right next to them is D125, and right next to D125 is D124. 124 had a ring camera. 125 had a still camera.
Likely the case.
And they went and collected video.
It's very likely that what the judge can see is a lot clearer than what we can see through, once it comes through multiple lenses.
From those 2 apartments. And importantly, on the day that Laken Riley was murdered, at 10:21 a.m., Jose Ibarra is captured on D124 coming out of his apartment with a bag, and now his clothes have changed. He's wearing different clothes than he was wearing about 40 minutes ago. And he has a bag in his hand, and he's walking towards a dumpster, another dumpster in their apartment complex. And that dumpster, by the way, had been emptied the day of the murder. So when the officers went to check that dumpster had nothing in it for them. But in the next door neighbors, still camera shot at 10:24 a.m., 3 minutes later, Jose Ibarra is walking back towards his apartment, empty-handed, nothing in his hand. So they searched the residence that day, and they found a few things of significance. Number one, they found 3 more black disposable kitchen gloves, which were sent to trace evidence for plastics and polymer examination, and they concluded that they had originated from the same source as the gloves that were recovered in the bushes. They recovered 2 of the defendant's Samsung cell phones, which you will hear some evidence out of, but they also found no bloody clothing, no bloody anything, and the shirt and the satchel that you see the defendant wearing in the video, the dumpster video, were never found. They're not in that residence. So what other forensic evidence The parties will stipulate to the prior Daubert hearing that this court has heard, so we will not be recalling the fingerprint evidence, but we will have a stipulation with the transcript and all of the exhibits that thumbprint, that latent print that was on the phone was sent to ACCPD that night. And eventually, the digital image of that thumbprint on Laken Riley's phone was compared to Diego Ibarra, Argenis Ibarra, Rosbelli, and Juan Carlos, and they were all excluded. They didn't leave that thumbprint behind. And it was matched to this defendant, Jose Ibarra. It is Jose Ibarra's left thumb on Laken Riley's phone. And the analyst or the expert who did
that right there is tying him into Laken. That's going to make it really tough to get away from that. That alone, there's a lot more, but that alone right there. His thumbprint on a victim's phone at a place where we press hang up, and we know that she made a phone call to 911 that was hung up. That right there is very damning.
Did that analysis, testified at the Daubert hearing. He showed the court 15 points of comparison that he found, and his results were peer-reviewed by another examiner. They were peer-reviewed blind, and she agreed with him. There's also DNA in this case, and you're going to hear about 3 different types of DNA: traditional, YSTR, and true allele. All true allele is probabilistic genotyping, but it is a computer software program that deconvolutes or separates complex mixtures of DNA. That's what true allele does. But before you can go to true allele, you have to start with traditional DNA. So all of the items of evidence that you're going to hear DNA results from started with the traditional DNA. They were swabbed, they were amplified, they were quantified, all the things that you do with regular DNA. But we do have some regular DNA results in this case. First and foremost, the jacket. The jacket found in the dumpster has blood on it. And in the blood for traditional DNA is Laken Riley's DNA and this defendant's DNA. And only the 2 of them. Jose Ibarra and Laken Riley's blood are on the jacket that he dumped in the dumpster. The rocks and the trees from the crime scene, they were also processed for DNA, for latent prints.
I don't know about you. Parts of this opening statement are giving me chills.
All right.
TV.
Hi,
On February 22nd.
Oh my gosh.
Let's go back in together where we left off.
Also processed for DNA, latent prints, and for everything we got. But on the rocks in the tree, just Laken's DNA, Laken's blood on the rocks in the tree. They attempted at first, which is protocol, to do what's called YSTR DNA testing on Laken's fingernails. So both her left and her right hands were swabbed by the medical examiner in this case, and they were both sent to DNA for analysis. YSTR is a better fit for trying to separate male and females because only males have Y chromosomes. And so they attempted YSTR first, and they were successful. The problem with YSTR, and the officers did gather the DNA of Jose Ibarra, Diego Ibarra, and Argenis Ibarra. They are brothers, and blood brothers share the same paternal line, and they share the same YSTR profile, unless there's a genetic mutation. And what the lab found when they tested the fingernails of Laken Riley is that, first of all, the left hand, there's nothing. No DNA of any other person other than Laken. But on her right hand, there was male DNA. And for the YSTR testing that they tried first, Jose Ibarra could not be excluded as the donor of that YSTR profile, and neither could Argenis, because, again, they're blood brothers. They share the same YSTR profile. But Diego could be excluded, and that's because Diego carries a genetic mutation that the lab was able to see, and he was able to be excluded as the donor of YSTR profile underneath Laken's nails. But after the YSTR was done, it was then sent to True Allele, along with a lot of other items. And when True Allele tested, and the data was sent into the True Allele program. It didn't test it, but when the data was sent into the True Allele program, True Allele excluded Argenis as the donor. True Allele excluded Diego, who had already been excluded by STR anyway, but True Allele matched Jose Ibarra to the DNA underneath Laken's right fingernails.
Yeah. Yeah. So we now have two types of forensic evidence. You got the DNA and the fingerprint, and including under her fingernails. So she's scratching at him. Yeah. And he's got scratches on him that are consistent with the, seem consistent with like female scratches. Yeah. Yeah. This is, if they can prove all the things she's claiming in her opening statement, he's cooked on the murder.
To this likelihood ratio, which I have before the court here, 10 billion times more probable than a coincidental match. I will tell you the gloves that were tested, that's all just Laken's blood, the black gloves that were in the bushes. There's a straw that was tested. That is the defendant's blood. I want to talk to you about that a little later.
Am I planning on streaming this tomorrow? Yes, tomorrow morning, 8:30 a.m.
And then the hat, the black Adidas hat, is also Laken's blood. And then the jacket also did contact swabs. So in addition to the blood on the jacket, they did contact swabs that were sent to True Allele. And again, it's the defendant and Laken on the jacket. But importantly on this dark blue jacket, also Laken's hairs that were wrapped around the button were sent to trace evidence. They are consistent with Laken Riley's hair. And of course, it's consistent with her long dark hair and all the microscopic analysis on it. Her DNA is on that jacket, so there's really no need to do DNA on the hair because her DNA is already on the jacket in form of blood. But they looked microscopically at her hair and it's consistent with her hair. But the important thing they found about several of the hairs, I believe over 15 of them, is that they were forcibly removed from her head.
Which that sounds consistent with dragging her by her hair. This freaking monster. Scum.
They did do a sexual assault kit on Laken, and several things were tested. But the bottom line is her entire sexual assault kit was negative for male DNA. Her clothing was looked at with AP, P30, you'll hear about that. There's no semen present. However, her underwear was sent to the trace evidence section as well, where they concluded that her underwear had been forcibly torn. So the medical.
Which that to me now sounds like you at least get him on attempted essay, as opposed to getting him necessarily on essay. Like I feel like I don't know. I'm curious whether you think just as far as guilt beyond a reasonable doubt. You don't have any of his residue with respect to showing that he completed anything. Now there could be essay in the form of not using of him using exclusively his hands and not using anything which is producing fluid. So there could be, and that would still be essay. But if you want to talk about guilt beyond a reasonable doubt, yeah, the torn underwear and the position, depending on the nature of the tear, that also would be relevant too.
Examiner, Laken.
Because what the defense is going to try and claim is that potentially she was dragged, and that's why if she was dragged by her feet, let's say, because in that case theoretically that could have resulted in the top coming up, or pants being and underwear being in this unnatural positioning, and that there was no essay or even attempt at an essay. So really, with respect to the tear in the underwear, the nature of the tear, I think, might better reveal the fact.
Was sent to GBI headquarters in Atlanta or Decatur, where Dr. DeMarco conducted an autopsy on her the very next day after her murder.
No, I don't think that's considered essay. Essay involves some level of fondling. usually. I haven't checked up the Georgia statute, but it would involve some level of fondling. Like let's imagine a scenario. Imagine a scenario of perpetrator, who's out to kill, corners his victim, tries to get away, and he ends up like dragging her away from the road, pulling her by her feet. So you can see how in that type of scenario, theoretically, her clothing might ride up. Both her leggings and her top might ride up, but that's not SA. It's not an objective of some sort of gratification, of a sexual gratification. So in that sense, I think that perhaps there could be a level of defense on that. Again, you ask me my gut is, this guy's a freaking monster, and he's a perv, and he's a sicko, and you ask me my gut, this monster tried engaging in SA, tried engaging in it. Do we have beyond a reasonable doubt that he did? There's evidence. There's a lot of evidence. It's not the same level of it. I think we all can agree it's not the same level of evidence that we have on the murder.
What the medical examiner found is that Laken had depressed skull fracture on the left side of her head, and she had 8 other lacerations on the left side of her head, which literally look like holes. She had a small subarachnoid hemorrhage on the right side of her head.
And this becomes important to sort of establish that there was an intent to kill, rather than, let's say, there being some sort of argument that the two of them had, and then she trips and split her head open. But that there was an intent to kill her, like the multiple lacerations of the skull. It's not like you fall down. Like they say, you don't run into a knife 8 times. So it's the multiple hits indicate a murderous intent rather than being some sort of fight that results in an accident.
And she had multiple abrasions to her face, her neck, and her torso. She also had what's called petechia in both eyes, which is consistent with some form of asphyxia. And asphyxia can come in many forms. It can be a drowning, but most importantly in this case, it can be a form of strangulation. It can be manual, it can be literature, it can be all kinds of things. But what the medical examiner said in this case is that Laken Riley died as a result of the effects of blunt force trauma to the head and asphyxia NOS, not otherwise specified. She can't really say if it was from chest compressions, maybe manual strangulation, but there was something going on in this struggle where this defendant deprived her brain of oxygen for long periods of time. And that was her cause and manner of death. But I want to talk to you about something that happened before, and it is count 10 of the indictment, and it is a peeping Tom. Shortly before 7 a.m., Jose Ibarra is seen on the trail cam, and this is a version of the trail cam.
I understand the incident with Laken Riley. She goes on a run 9:03. She comes across him 3 minutes later in 9:06. By 9:24 or so, she's dead. 9:26 or so. In 20 minutes, she's dead. So that's at 9:03. Now we're talking shortly before 7 a.m. And this is why the prosecutor is properly portraying him as someone hunting for a victim, as we're about to see here.
All right, this is the angle you'll see. And you'll see an individual, and the state will be the first to tell you this video quality is not fantastic. But there's more than just this video. You'll see an individual wearing a dark hoodie, eventually a dark hat, black gloves, and holding a styrofoam cup. And UGA attempted to enhance this video. GBI Cyber attempted to enhance this video. This is about as good as it gets. You can see a bag. They've studied this video 1,000 times. You'll hear the things that they saw in looking at these videos. The male is seen on the trail cam exiting the defendant's apartment complex. That's how he gets onto the trail. It's further beyond outside the scope of this exact clip. But he gets on through a path from the defendant's apartment complex to this trail that leads onto campus. And this is Rogers Road. This is UGA Village housing for graduate students. And this is a bus stop that's used by students to take the bus to get to a class. At 7:01 a.m., this individual is seen at this door that you're going to see in the bottom or the middle of your screen. That's apartment 114. And in that apartment, 114, Building S, lives a graduate student. She's an Indian national. Her name is Tejaswi Sarathi, and she is here at the University of Georgia studying.
You can see him up here in this area where he starts pounding on her door.
This defendant is seen trying to open her door at 7 o'clock in the morning.
Thank you, Kim.
And there's about an hour's worth of video that was watched by UGA PD that between 7:01 a.m. and 7:57 a.m. on the 22nd day of February 2024, about 70 minutes before Laken Riley is murdered, this defendant goes to the door of apartment 114 6 times. Twice they can see on video that he attempts to open her door. And at one point you'll see in the video where he ducks down. And that is because at some point, the student inside heard him at her door, and she approaches him at the door and says, "Excuse me." And she will testify to this court that when she said that, she's looking at her peephole, he ducks down. And you can actually see that on the video. And just here's a portion of her 911 call where she calls at 7:57.
Talking with some of my colleagues as we're watching.
Oh, gosh. We don't need you.
Someone was trying to open the door, and then I said, "Excuse me," and then they just ran away, and then now they're trying to look through my window.
Look to my window.
What's going on?
So she says
That's the peeping Tom charge. This is the window that he looks in.
she was in the shower and she heard her door jiggling.
Yeah.
And she said
Tough
that
times.
somebody is at her door. She says, "Excuse me," he ducks down and he tries to look through her back window and does look through her back window. This is her back window. This is the backside of Building S, and this is exactly how it was that morning. This is body cam footage of Officer Bridges, who's one of the officers that responded. Her blinds are open wide. They're open, not only open, but they're pulled up more than halfway. The right side is her living room. The left side window is her bedroom, wide open. Her blinds were that morning. She said that's how she kept it because it was kind of a dark place, and it was more comfortable for her to have some light in. And that's how her windows were. And she said when she turned around, she could see the person who she can't identify. And we're the first to tell you she can't identify him. She didn't get a good look at his face. He had that hat over his face. He had a hood on. She describes the clothing. Dark hat, dark jacket. Didn't get a look at his face because when she looked through the peephole, he ducked down, but she could see him peeping into her window, looking into her window. So the FBI CAS team is a specialized team with federal government that analyzes digital evidence. And they were brought in this case to look at data from the defendant's phone, the victim's phone, cell phone records, all of these things. And some of the data that they got from the defendant's cell Samsung, one of them, which is 1B7, which you'll hear a lot from, is called Rubin data. And Rubin data is something that's collected by Samsung. And
One of the things I like about this prosecutor's style is she explains how the science ties in and the the digital evidence that they have operates, because fingerprints, DNA, these are terms that an old boomer like the judge or myself is familiar with. But when you're referring to these different types of digital evidence, walking through the distinction of these different types of things and how they operate is it's just very clear and it's very on point, and she does a really great job of breaking it down, which is this is a phenomenal opening. It really is. It's a very lethal opening, and then everything about it is just, it's a very impressive job by Sheila Ross.
FBI CAS team analyzed Rubin data, looked at the Rubin data in this case, and at the time of the peeping at Tasia Swee's apartment, the defendant's 1B7 phone is right over her house. And these are the digital points by the FBI. But also, there is a white styrofoam cup. In the video, you can see black gloves and the white styrofoam cup of the peeping. This cup was found by UGA PD as they were coming onto the trail to come to Laken Riley's scene. They thought it was unusual because there's no trash out there usually, and it's just sitting there. They collected the cup, and you can see in this next image, if you see where the retaining pond is in the middle of the screen, the cup is near there. So in between Building S, where Tasia Sweet lived, and in between where Laken Riley's body was found, was this white cup. That white cup was collected and sent to the crime lab at the GBI, and it is the defendant's DNA on the straw of that white cup in between the two crime scenes. So also, out of his phone and out of his social media, the defendant, when he woke up that morning, kind of did us a huge favor and started taking pictures of himself. And here are the pictures that he took of himself and posted on Snap, and also can be found in his phone. And one was taken at 4:30 a.m. The second one was taken at 5:37 a.m. And you see in that one that he is wearing the black Adidas cap with the stickers on it, with the same jacket, with the hoodie. Also, he took pictures of himself wearing the same shirt that you see in the video of B32 and the bag that was never found that you see on the side of him in some of the videos taken on the day of Laken's murder. And also you can see from, again, D124 and D125, the day before the murder, he is wearing them the evening before the murder. So this is the 21st at 9 p.m. He's wearing the same clothes. So in the end, Your Honor, that is a summary of the evidence that the case, summary of the evidence that the state has in this case. You will hear forensic evidence. You will hear digital evidence. You will see videos, all pointing to the same conclusion, that this defendant murdered Laken Riley, and he also peeked Tasia Sweet's apartment. At the close of all the evidence, we are going to ask that you find him guilty on every count of this indictment, because the state will be able to prove every bit of it. And we ask that with your verdict, the close of the evidence, that you bring justice to Laken, Tasia Sweet, and this community. Thank you.
Excellent. Excellent job. Really good. Really good.
What a great job with that opening statement. Sheila Ross,
I just
a
totally
special
disagree.
prosecutor, brought in to handle this case, just delivering that open on behalf.
Yeah, they're not saying their best. She was very, very good. She was very, very good. She was brought in special for this, and she did well. She did well. So
Behalf of the state.
Let's hear from the defense. Give us the defense. Is it short? Here he is. Dustin Kirby for the defense. Oh, that's what you. Oh, yeah, they're not saying their best. Yeah, you're right. Yeah, like Trump always says, right?
Of Laken Riley.
Judge, the evidence in this case is graphic and it's disturbing. What happened to Laken Riley is graphic and disturbing, and it is a tragedy. The loss of any life that young, and apparently
this is something they inserted afterwards. I don't think that this is what happened. I don't think we're going to have this tomorrow.
Full of promise is a tragedy. And I'm sorry that the family is having to go through this and be here for the presentation of this evidence. People have used this case for their own personal gain, financial gain, political gain. And while this process has its place for testing evidence, it's very poorly suited to healing hearts and minds. So it's the evidence that we have to talk about. And the evidence in this case is very good that Laken Riley was murdered.
You really want to start? The first thing out of your mouth is a lot of evidence that she was murdered. Okay. That's an unorthodox strategy. I'm not going to kid you. That's an unorthodox strategy.
The evidence that Jose Ibarra killed Laken Riley is circumstantial.
Okay. You're admitting that there's circumstantial evidence.
The evidence that anyone had any intent or certainly committed any sexual assault is speculation. Most importantly, in this case, you'll hear no.
I would have said that all of it was speculation if I was in his shoes, but I'm happy for them to be owning it.
No evidence that a sexual assault was committed. You'll hear nothing from the GBI, the FBI, UGAPD, ACCPD, that after looking at all of the evidence in this case, scouring for anything that could help prove this allegation in the state's indictment, that they found any biological evidence that would suggest that, any physical evidence that would suggest that. There's no.
And I just want to tie in here. It's an interesting moral question you can have. Some of you are probably thinking, okay, if we have a ton of evidence beyond a reasonable doubt that he's a peeping Tom, should that play in? And he's a peeping Tom, not just in general, but he was a peeping Tom like an hour beforehand. Should that play a role in leading us to conclude that there was, at the very least, an attempted essay, if not an actual essay? That this guy is some creepy, disgusting horn dog who is trying to staring at women, that when he had Laken Riley and drags her off into the forest there, that there was an attempt. Should that knowledge about his persona lead us to conclude that it's more likely, should that be a factor in determining that it's more likely that he engaged in or attempted to engage in essay? Me personally, I think it should. That's my personal take. I think it should. And the reason I think it should is because it shows his state of mind at the very least. That the dude was, for lack of a better word, his hormones were raging. It's indicia that his hormones were raging. So much so that he's breaking the law beyond already breaking the law, breaking into this country, but that he's breaking the law and peeping in on women who are coming out of the shower. That, the dude doesn't seem as if there was much time. He never seemed to go home to relieve that urgency. I think it should be, personally. And that's an interesting point also. Lack of boundaries. Yeah. Lack of boundaries. But that when it comes, lack of boundaries in general relates, I think that's to a person's nature or, who they are as a person, which you're not supposed to use their character and as a way of assassinating them, that they committed this specific thing. You want the state to prove that they committed this specific thing. In this case, because it happened the same morning, and we see he has this. When you start getting into character testimony or evidence of a immoral heart, so to speak, that's not supposed to play in to whether or not he committed this particular crime. But and here's the counter that defense can raise. It's a fair point. But I know this is what all the studies say. But it's rage manifesting as an appetite, right? I mean, I'm not saying, okay. So maybe it's the same rage that's having him leer in on women while peeping in on women. Well, the point is that this guy's hormones are raging, and the manifestation of that is in a sexual direction. I'm not saying it's love. You know what I'm saying? Like
injuries that are consistent with the sexual assault. And in this case, it's an effort to explain a tragedy, but it's not based on evidence. The evidence that Jose Ibarra killed anyone is circumstantial.
It's really not much of a help. Because very often, most cases in criminal defense, and most criminals who are convicted is based on circumstantial evidence rather than eyewitness evidence.
The state's,
everyone loves saying, "Oh, circumstantial." There's different levels to circumstantial evidence. You know what I'm saying? Circumstantial evidence that a person owns a gun, that a person owns a Glock, that a person is killed with a Glock. That's one level of circumstantial evidence. The striations on that when you fire the Glock off, the striations on the bullet being unique to that particular Glock and what's found at the scene of a crime is a higher level of circumstantial evidence. Fingerprints are a pretty high level of circumstantial evidence. It's not the same thing as like, oh, you were in the forest. No, your fingerprint is on the phone. That's a high. You being in the forest is circumstantial evidence. Your fingerprint on the phone is circumstantial evidence. But no one would say those two are the same.
presentation in their opening had a lot of detail about information, again, that showed that this event happened. But upon a closer look at the evidence that links Mr. Ibarra to that event, it is lacking. You'll hear that his phone was in the area, and you'll hear that the cast team that ran the locations of this phone. And
that his skin is under her fingernails.
There is good evidence that the phone itself was in the area. What you'll also hear, though, is that when they looked into this phone, when they did a close examination of who was using this phone, it wasn't just Jose Ibarra. It was other people in that apartment who were using this phone. And that comes through an investigation into the accounts that were used through this phone, and also from people who met other people associated with this phone who had used the phone to message people. And so while the phone was there, that's true. It doesn't show that Mr. Ibarra was there. And you'll hear that Mr. Ibarra's fingerprint was on Laken Riley's phone. But you also hear that he was wearing gloves, supposedly. And that this hole that was supposedly in the gloves that they found would not have left that mark. you'll hear that someone in that video, in the so-called dumpster video.
That's a fair point there. That's actually a really.
No, it's not, idiot. Your hole in a rubber glove, the thumb can come out of the glove completely. Thanks for weighing in, honey.
This is Court TV.
So, but what we are seeing is that he's working very hard to try and basically, cast doubt. He's doing what he's got to do as a criminal defense attorney. He's trying to find some way to find holes in the evidence.
His opening statement.
Was wearing an Adidas hat. That's true. When they find that hat, and specifically the hat that was tested in this case, it was worn by Diego Ibarra, not Jose Ibarra, Diego Ibarra. And you'll also hear, and the state will ask you,
I'll come back to this,
to consider different types of forensic evidence and to suspend your understanding of how that evidence is evaluated. Because while they will say that Mr. Ibarra's DNA was present at the scene, what they'll tell you is that
thank you, brother,
without this software that we can't test,
and that's what he has to do.
Software used by the GBI. Without that, their expert wouldn't have been able to say whose DNA it was. She wouldn't have been qualified to testify about whose DNA that is. So they have to use a machine. And they're going to ask you to trust that machine where the human being isn't good enough.
So
but with this fingerprint, they're going to ask you to trust a person because a machine isn't good enough. When they run those fingerprints through the database of fingerprints where they know Mr. Ibarra's fingerprint is, it doesn't come up. And so while a machine is good enough in one...
That's a great point, Shiloh. He probably had to stick, if he wanted to turn the phone off, want to hang up on it, he might have ripped it himself in order to get his thumb out. That's a great point.
Situation to try to convict Mr. Ibarra is not good enough in another. And it's this kind of gymnastics that it will take to tell the story with this circumstantial evidence. We waived a jury trial in this case with the hope and trust that despite the nature of this evidence, that you could come to a verdict that was not just a way of easing this family's suffering, but it was based on an impartial and honest assessment of the evidence in this case. If that happens and the presumption of innocence is respected, there should not be enough evidence to convince you beyond a reasonable doubt that Mr. Ibarra is guilty of the crimes charged.
So there you go. There you go. He's basically trying to hit on that there's not enough evidence here, which if you're in his shoes, you have no choice. That's what you have to do. That's what you have to do. But that's pretty much the weakest. This is a defense of last resort. It's not a defense that any defense attorney is looking for when they hear about a case. This is like, I got nothing. So the evidence isn't good enough. If you're rooting for him to be convicted, which I'm sure most of you are, it's a great start for the prosecution. I'm just going to give you a recap here. I'm going to go through a recap that I found here as to what happened on day one, so we can we can get an overview as to where we're at as we start tomorrow morning. I do plan on live streaming this at 8:30, which is only 6 hours away, and I still have to set up my stream. And oh my God, when the hell am I sleeping? All right, so we're going to do this real fast. I'm going to get on out of here because I'm already tired. All right, let's do this real fast. We're all caught up. There was a whole bunch of people who testified on Friday. A whole bunch of people. I'm not going to go through Ross's opening statement because we just spent an hour and a half watching that. So let me scroll on down. Dustin Kirby, a 9-minute opening statement. All right. Prosecution also brought up Georgia Bureau of Investigation crime scene specialist and 2 detectives testify. First detective talked about the evidence he collected at the scene, including a watch and later an impression on a phone. He also said that he went to sorry about that. He also said that he went to a second location where they found a blue jacket thrown in a dumpster and gloves hidden in a bush. Second detective called to testify was the lead investigator at the time of the crime. He talked about how they spent around 8.5 hours in the scene. Throughout the day, they were trying to find Riley's phone. Body camera footage was shown when officers found the phone they believe belonged to Riley. Before the court adjourned for the day, the defense argued they did not want cameras in the courtroom, but Haggard denied this request. The defense then asked if it would be possible to get rid of a camera position right in front of the defense table, arguing that the main point of having cameras in the courtroom was allowed for the public to see what is happening, and no person in the public has the view of the defense table. Haggard said he will think this over and decide when they meet again. So there also are other people who testified. I don't know why they didn't cover that in here. That's very strange. Here it is. Riley's roommates took the stand. I missed this part. Riley's roommates took the stand, testified what occurred that day. They said they became worried about her when she didn't return after her run, pick up her phone calls, or when the location tracking app they used said she hadn't moved from a spot for a long period of time. 2 of her roommates went on the trail around 11:30, and one of them found what they suspected was an AirPod that belonged to Riley, and that's when they called the University of Georgia police. And then when they got to the scene, they began their search around 12:20 p.m. After an approximately 21-minute search, they found an unconscious body who they believed was Riley. The officer who found her attempted to perform life-saving measures. And, yeah. So there you go. So far, testimony has come in the form of 2 roommates and also the officer who found her, who supposedly, and from what I've heard, the testimony has all come across as highly credible by most who have seen it. So there you go. That is where we are at. Tomorrow trial resumes at 8:30 a.m. God help me. And I plan on being here. You cannot find a link for it yet. I do plan on putting a link up for this within the next 15, 20 minutes or so. You'll probably see a thumbnail that looks exactly like this and just has added onto it live trial. So if you see this thumbnail and, just look for live trial, and I'll mark it like day 2 morning, even though it's the first day I'm covering it, but it's day 2 of the trial. So I'm going to put in live trial and day 2 morning, and it's going to be the same thumbnail. The links will be on YouTube. Links will be on Rumble. And you'll be able to watch along with me as hopefully we watch this guy march towards a very, very, very lengthy sentence. And I'll try and break it down for you. All right. Someone's saying you had something light for me. Should I close with something light? I should close with something light. I actually have my own thing, which is kind of light. We'll close with something light. And after this is over, I'm just going to tell you right now, offhand, lamb meat, not meant for you. It's meant for they, them, not for you. And don't eat the bugs. And yeah, this is pretty light. This is pretty good, actually. And I'll see you all tomorrow at 8:30. 8:30. Don't be late. Don't be late.
See, was there an apology today?
This is after Trump met with Biden. So there's a question whether there was apology today. Being asked of Karine Jean-Pierre, who doesn't look happy. She doesn't look happy.
I'm sorry.
Was there an apology from
Apology
from President
whom?
Biden for the words, some of the words used?
An apology from the President Biden.
To President-elect Trump for some of the words that was used on the campaign trail.
Look, and I've answered this a couple of times about a threat to democracy in the past week. The president is going to always feel obligated to be honest with the American people.
And why wasn't he honest for the last year about his incapacity to serve or in calling Trump? Oh.
What he says still stands.
She looks angry.
And it's not just him. You heard this from former staffers. You've heard it from the former chief of staff, John Kelly, and others. You've heard it directly from the president-elect, the former president, about enemy of the people. Very, very clear. Very clear. What we want to be also very clear about is the importance of listening to the will of the American people.
Even if they bring in an enemy of the people. All right, well, there you go. Oh, that was cute. I thought that was cute. Tomorrow morning, 8:30 a.m., you're going to see links for it soon. Sign up. If you're here, please like, share, subscribe. Drop a comment down below. Any thoughts you have about the trial, about whether SA has been, do you think they're going to get him on SA or just on murder, or what your thoughts of the trial are? I'd certainly love to check that out. And I will see you tomorrow morning, 8:30 a.m., live streaming the trial of Jose Ibarra for the murder of Laken Riley. Until then, take care of yourselves. Have a great night and Godspeed.